I know you probably won't believe it, but Keir Starmer's been accused of being a bit of a hypocrite now that Lucy Connolly has been released from prison, and of course all of this has hit the headlines once again. Mainly because there are lots of people who are given suspended sentences rather than actually going to prison, and many of whom the general public, I presume, would think should really have gone to prison for their offences. I'll cover some of those in a minute, because I can't really do that in the first minute or so of YouTube, but Keir Starmer, as I said, is being accused of being a bit of a hypocrite, because if we go back to this article here, he effectively supported the prosecution and imprisonment of Lucy Connolly, although he said it was down to the courts and so on. He said here, "I am strongly in favour of free speech. We've had free speech for a very long time and we protect it fiercely. But I'm equally against incitement to violence against other people." Now, that by itself might be okay. You might think, well, he's in favour of free speech, but he's also against incitement of violence, as I am. I always encourage people, whenever I do these videos, not to make those kind of comments online, and you shouldn't make those kind of comments online, and so on. However, that said, Keir Starmer also was part of the guidance previously published and backed it up with speeches and so on, where he said that where somebody makes a statement which is then quickly deleted and they show remorse about that, a prosecution, and this is the bit highlighted here, is unlikely to be both necessary and proportionate. So I'm going to explain what that means and compare it with some of the other offences where people have not been sent to prison. But first of all, if you like this rather brutally honest analysis of the law and how it applies and holding people account to what they say, please do hit the like button, and that helps my video reach a wider audience. Subscribe to the channel if you haven't done so, it's free. I've got a number of channels on here now. If you want my personal views, check out my Off the Record channel, link below. And if you're worried about digital ID, do check out my secrets video, link below as well. You absolutely need to watch that if you're worried about digital ID. So thank you very much for that. So let's go back to this post here, because on the one hand it says, if swift and effective action has been taken by the suspect or others, for example, service providers, to remove the communication, so delete the post, the tweet, whatever, which is what Lucy Connolly did just a few hours later, if swift action has been taken, then they really shouldn't be prosecuting them. Now, there is a possible sideline to that, because many lawyers have said that whilst this is not an exhaustive list of mitigating circumstances that must each be considered on their own factors and individual merits, but many lawyers have also said that in the guidance, if the offence is one of public order, such as inciting racial hatred, then that should be treated separately and suspects would not necessarily benefit from the same protections. In other words, if they are inciting racial hatred, that should be treated somewhat differently. Now, you may have views about that, you may agree with that, you may not agree with that, but either way, Keir Starmer followed up the publication of this guidance in interviews and said the following. He said, "There's a lot of stuff out there that's highly offensive, that is put out spontaneous basis, that is often taken down pretty quickly, and the view is that those sort of remarks don't necessarily need to be prosecuted. This is not a get out of jail free card, but it's highly relevant. Stuff goes up on Friday and Saturday and might come down the next morning." Now, if that's the case, that a lot of people will say that it shouldn't have happened, that person has accepted it, but really you don't need a criminal prosecution. It's a relevant factor. Now, I absolutely agree. I don't think that things like this generally should be prosecuted, where the person has accepted that it was wrong. Now, there is the sticking point in this case where Lucy Connolly did sign that declaration. I have my reservations about that, but that's entirely another issue. I've talked about that in other videos. But now let's get to another discussion about why people believe this is two-tier justice. Now, I've said before, I've compared the sentencing guidelines with different offences and the legislation with different offences, and they all turn on their own particularity. And so you cannot really compare two offences directly with each other, because the way they are prosecuted is different, the elements of the offence are different, the wording of the legislation is different, and then ultimately, if they're convicted, the sentencing guidelines are often wildly different. And wrongly so, I think, in many people's eyes, which results in cases like this, which is why people believe that we have a two-tier justice system. Not two-tier necessarily in the sense that two people have exactly the same prosecution, exactly the same facts, and exactly the same process, but get wildly different outcomes. That, of course, would be obviously wrong. But as I say, when you look at these offences, it still feels wrong to many people. Let's take a look at some of these examples. Now, we have Hugh Edwards, rather famously in September 2024, was found to have a whole heap of images that he really should not have had, which is a criminal offence. Obviously, he pleaded guilty to those charges, but let's just remind ourselves of the categories. Now, I'm not going to go into great detail on this platform. You can look that up yourself. But if we take a look, we can get an idea. So he pleaded guilty to 3 offences of making indecent images. Those comprised 7 Category A images, the most serious, 6 of which were video, 1 was a still, 12 Category B, all of which were videos, and 22 Category C, 1 was a video and 21 still. The estimated ages of those involved in the Category A images were generally around 13 to 15, but with 2 of the moving images showing someone around the age of 7 to 9, and the estimated ages for the children present in the B images were generally around 12 to 14, and in Category C, 12 to 15. So given all of that detail and the nature of the offences, you might reasonably believe that someone like this deserves to go to prison, even if, on the face of it, they are at the bottom of probably a long chain of people within a network of criminality. Nonetheless, you might still believe they deserve to go to prison. However, he only received a suspended 6-month prison sentence. So a 6-month sentence, but suspended for 2 years. So he's sort of monitored for the next 2 years and he goes on the register and so on. But nonetheless, he didn't physically go to prison. And even if it wasn't suspended, it was only a 6-month sentence. So the suspension bit comes afterwards. It's not as though, well, because we're suspending it, we'll reduce the sentence. That's not how it works. The sentence is decided, and then it is decided whether or not to suspend that sentence. So I've had situations where I've achieved a suspended sentence for my client, but it's on the basis that you reach a sentence first. And so sometimes a guilty plea is absolutely material to achieving a lower sentence. But then you are at the whim of the court as to whether it's suspended, unless, of course, you get an indication from the court beforehand. But either way, this was a 6-month suspended sentence. Not something you might expect. Let's have a quick scout down because credit here where it's due. I'll link this article below. But scanning down below, Jack Davies in December 2024, similar nature of offence, had a 12-month suspended sentence, arguing that he should get the same as Hugh Edwards. Scanning down further, Reese Newman, August 2024. This was, albeit historic, still just as serious, historic rape of a child under the age of 14. Again, a suspended sentence of 2 years. Now again, you would expect somebody to go to prison for this kind of offence. This is why people think it's a 2-tier system. Moving down, because there's lots of examples like this. A domestic abuser given fewer than 2 years. Again, a suspended 21-month sentence and a 10-year restraining order. And the details here are horrific. And again, possession of images that they shouldn't have, a suspended 8-month sentence. And again, sexual assault and indecent exposure, a suspended 18-month sentence. And again, 7 charges of possessing terrorist information, suspended 18-month sentence. So for anyone to say that there isn't a 2-tier system, that can only really be justified by saying that we are not comparing 2 identical offences where one person went for a lengthy prison sentence and the other one didn't. Comparing different offences obviously leads to different results. And in these cases, obviously led to suspended sentences. But in Lucy Connolly's case, she had a 31-month prison sentence, of which she has now served a portion and been released today. So I just thought this was worth drawing attention to because this is why people believe that this is a 2-tier system. Now, as a lawyer, I can explain to you why it's different. That's not to say that I am justifying why it's different. I always get comments to say, you're justifying it, you're part of the system. That's not the case. I'm a human being. I have my own views. I try to keep those views off here and just explain things to you. I reserve my own views for my Off the Record channel. Please do subscribe there down below. We are racing towards 100,000 subscribers over there. Please do jump over there and I'll give you my personal views on all this. So whilst I can explain why they are different, I am not justifying why they are different, and you should not necessarily think so. I mean, you may think so. You may think it's perfectly justified. That's entirely a matter for you. But the main reasons they are so different is the offences are worded so very differently, and the sentencing guidelines written for each of these are so very different. I've read all sorts of things saying where these meetings have took place where they said not all sex offenders need to go to prison. Now, I think that's a bit out of kilter with the general view of society. But either way, let me know what you think down below. Please do subscribe to the channel, and as always, thank you for watching.